Please be seated. Good afternoon, everyone, to the finale of the 21st Annual Osgoode Cup. For today's purposes, I'm Chief Justice Rappos of the Supreme Court of Osgoode Hall. So welcome. In real life, I am Associate Justice Sam Rappos. I'm an Associate Judge of the Superior Court of Justice here in Toronto. I've been appointed to the bench 2 years ago today. And I'm going to ask, starting my far left, and go across for the judges for today's final panel to introduce themselves to the looters and the crowd.
Hello, my name is Omar Heredai, and I am a litigator.
My name is Chris Diaz, and Justice Diaz, so I'm also a civil litigator.
My name is Dahim Imami. I'm an assistant crown attorney.
My name is Matt Fisico. I'm a criminal lawyer.
My name is Jake Humphrey, and I'm assistant crown attorney.
My name is Laura Eckford, and I'm an assistant crown attorney.
My name is Stephen Marchand. I'm a commercial litigator at Sykes & Elliott.
And my name is Jocelyn Heaton. I'm a criminal defense litigator.
Okay, so for today's final round, each speaker will have 15 minutes to present their arguments to the court. We will focus and keep the parties on time. If you need a brief indulgence to finish off a point, feel free to ask for it in advance. And there will be a brief reply if necessary for the appellants. So seeing that there's no other business that needs to be addressed, I call upon the appellants to commence their submissions to the court. Yes, just be mindful of the strength of your voice in this large room. So the microphone is there to pick up your voice for the purposes of the recording, but in terms of, I don't believe it's amplifying your voice, or if it does, it may not do it sufficient. So just be mindful, and this goes for all the speakers, of how loud your voice is, and just to fill up the room as much as you can. Okay, please proceed.
Good afternoon, Justices of the Supreme Court of Osgoode Hall. My name is Helen Wu, and with me is my co-counsel, Michaela Mifsud. We are here today on behalf of Mr. Campbell, the appellant in the case at bar. Would the court require a brief summary of the facts?
Not necessarily, Ms. Wu. You can move on to your submissions.
The appellant has 4 submissions to make today. I will address the first 2, and my colleague will conclude with the final 2. First, we submit that Mr. Campbell did have a reasonable expectation of privacy in his text message conversation. Second, we submit that it is possible that the search by police could be characterized as an interception requiring a Part 6 authorization. Third, we submit that the police conduct was not authorized by Section 11, Sub 7 of the Controlled Drugs and Substances Act. And finally, we submit that the evidence should be excluded under Section 24(2) of the Charter. We request that this court allow the appeal, set aside the appellant's convictions, and enter acquittals. Justices, we are faced with a different police technique today, a new police technique that has not yet been considered under Section 8, a technique wherein the police hijack the identity of Mr. Gammy to speak to Mr. Campbell over text messaging. America establishes that the private nature of text messaging is very high because there is a potential to reveal private information. America clearly establishes this. At paragraph 34, it is noted that people are more inclined to discuss private affairs over text precisely because they believe it will not be revealed to the public. And at paragraph 35, it is noted that there is, quote, no more discreet form of correspondence. As Justice Jamal asserts in the court below, this sort of information is something that anyone would reasonably want private from state intrusion.
But yet the court had the opportunity to establish essentially a blanket protection. All text messages, all electronic communications are subject to this, but chose not to. In your submission, where do we draw the line? What makes this situation different, that a reasonable expectation of privacy exists when it doesn't always?
In this particular situation, we would turn to the police conduct and the intrusiveness of the police technique in question. The police did more than simply look through Mr. Campbell's text to Mr. Gammy. The police, unbeknownst to Mr. Campbell, put themselves in conversation between two people with a pre-existing relationship, hijacking Mr. Gammy's identity. This technique, again, as I've said, has not yet been considered under Section 8. We take a case like Mills. This is different than that case. Indeed, Justice Brown's reasons in Mills concerned and surrounded the fact that police impersonated a stranger to Mr. Mills, and not only that, they created the entire relationship themselves. The fact in Mills that the police had control over the entire relationship had lessened Mr. Mills's expectation of privacy. In this case, however, there's already a pre-existing relationship which police are intruding on and considering the high
pre-existing relationship between your client and Mr. Gamby, or between Mr. Dew and Mr. Gamby. And factually, your client just hijacking Mr. Dew's identity for the purpose of these text message exchanges?
When we consider our Section 8 analysis, we're looking at intrusions by the state. In this case, Mr. Gamby at least somewhat knew, or Mr. Campbell at least in some way knew Mr. Gamby. That's a pre-existing relationship. And the appellant submits that that would be completely different than the case of Mills, in where they create a fictional persona that they know must be a stranger to Mr. Mills because they've created that persona. In this case, where the police are intruding on a pre-existing relationship, we would say that that is very significant and very intrusive.
Does the nature of that pre-existing relationship and the sort of strength of that pre-existing relationship matter in the analysis?
The strength of Mr. Campbell and Mr. Gamby's relationship. It does have a factor in this analysis. We concede, of course, they were not the closest people, but the mere fact that there is a pre-existing relationship, we would submit that this differentiates this case from previous Section 8 cases, because the police are actively taking the persona of a real live person.
Is it that there's a pre-existing relationship, or is it just that they're taking the persona of a real person that exists?
It's both, Justice. So it's the fact that they're taking the persona of someone that exists, but it's important that Mr. Campbell knows Mr. Gamby, because that means that Mr. Campbell believes that his...
Well, the wording that the court used is that the appellant barely knew Mr. Gamby.
Yes, but even those words, Justice, we would submit, still signify a relationship. It's a pre-existing relationship. That's completely different than a fictional persona. Again, and this sort of technique is especially intrusive. It is different than creating the entire relationship and intrusion itself. And the appellant will now turn to control, and we anticipate that our friends will submit that since Mr. Campbell did not directly own the phone, that this diminishes his expectation of privacy. However, as established in America, someone does not lose control over information simply because another person has access to it. While Justice McLaughlin asserts in America at paragraph 43 is that, quote, the issue is not who owns the device through which the electronic conversation is accessed, but rather whether the claimant exercised control of the information therein. Since Mr. Campbell exercised control over the informational content of the text messages, he did not relinquish all control in this case, and he especially did not relinquish his reasonable expectation of privacy. Control is not determinative of our analysis. We look to the totality of the circumstances. Thus, seeing the private nature of the subject matter, the intrusiveness of the police technique, and since Mr. Campbell still exerted control over the text messages.
Counsel, I understand that you say you're not asking us to create a blanket rule with regards to control, but it appears that the only factor you're relying on is the fact that Mr. Campbell had some control over the text messages that he's sending Mr. Gamby. So it sounds to me like, in effect, you're asking us to create a blanket rule that text messages will always have a reasonable expectation of privacy. Is that your position?
It is not our position, Justice. Our position on control was simply that control is not determinative and that Mr. Campbell, like Mr. Merica, like Mr. Cole, did not lose all of their control. We're looking at the intrusiveness of the police technique as well.
You mentioned also the private nature of the communications. Are you talking about the sort of type of communication, or are you talking about the content? Because when we're considering this, there's lots of discussion of core biographical information, and what type of information are we actually seeking to protect here, when on the face of it, the first 4 text messages received seem to be narrowly and exclusively about setting up a drug deal?
Well, Justice, our analysis here is content neutral. When we consider the fact that the question before this court, as noted in Wong, is whether Canadians generally have an expectation of privacy in a given case, despite whether or not illegal activity is actually engaged.
Counsel, isn't the question here actually whether or not the expectation of privacy is objectively reasonable?
Yes, Justice, that is the question before this court. We're looking at, so the appellant is taking the factors of control, which the appellant did have some level of control over the subject matter. The private nature of the subject matter, which is clearly established in America, is very high, a high potential to reveal biographical core of personal information. And third, the intrusiveness of the police technique to hijack the identity of Mr. Gammy, intercept this conversation between 2 individuals with the pre-existing relationship.
On the facts of this case, though, the police had all the biographical or core information that they could have surmised from Mr. Campbell in the 4 text messages that popped up. His location is elsewhere, he's part of the drug trade, he's a courier at that, well, they thought it was due, so he's a distributor. He's clearly not where Campbell is. And their conversations with Mr. Campbell, who they didn't know was Mr. Campbell, didn't elicit any information aside from, effectively, how is this transaction going to come about? So where is Mr., as the intermediary, as the FedEx driver, the UPS driver, where's Mr. Campbell's expectation of privacy here?
Well, Justice, when we establish potential, and as noted in Spencer and later confirmed in Bajkowicz, we're not looking about the actualization of that potential. The potential of the subject matter is merely about the subject matter. America establishes that text messages have the potential to reveal a biographical core of personal information, whether or not that is actualized. In Bajkowicz, too, it is the case that the tendency of the IP address that tended to reveal personal information attached the reasonable expectation of privacy there, despite the fact that the police did not take the IP address to the third parties, which was the concern about the potential of the subject matter. So it does not need to be actualized to still be a potential to reveal a biographical core.
Sorry, where is the line for that, counsel? Isn't any text message exchange, could it not lead to the potential of sharing biographical information? You must be able to draw a line somewhere to delineate, no?
Well, Justice, America establishes that, yes, text messages generally have this potential in the medium of text messaging, but when we go to reasonable expectation of privacy, that is determined on the totality of the circumstances, and we look, say, at the intrusiveness of the police conduct. I'll as well turn to interception at this point as well, and to that point, the appellant submits that it is possible that this search could be categorized as an interception.
Yeah, are there instances where you have text message conversations that don't run the risk or potential of revealing core biographical information?
Justice, our submission is that the nature of the subject matter has the potential to reveal a biographical core. That was what was established in America.
So are there subject matters that don't reveal the information?
Of course, Justice, there are different subject matters that might not reveal a biographical core, but text messaging, something we feel will be private, especially from the state, America clearly establishes that that has the potential.
Sorry, go on.
Counsel, if we're looking at the subject matter, is it objectively reasonable to provide privacy protections to transactions involving illicit substances?
Well, Justice, again, our approach to Section 8 is content neutral. The fruits of the search cannot justify a violation of Section 8, right? The fact that, again, the question in Wong, whether Canadians generally have this expectation in a particular case, whether or not there is actually legal activity engaged. That's the question that we're asking. I'll turn again to interception. The Crown Intel's Communications establishes the need for a broad and non-exhaustive interpretation of Part 6. It was established that a technical approach to defining interception would, quote, render Part 6 irrelevant in emerging electronic and text-based technologies. In this case, the police acted by texting to insert themselves into an ongoing conversation between Mr. Campbell and Mr. Gammy using
Part 6 authorization would necessarily engage this idea of sort of third party coming between an existing communication. In essence, what the police did here is that they became the second party. They aren't this third party hovering over a conversation that's happening. They're inserting themselves as not a third party, but the second participant in an ongoing conversation. Is that not what Part 6 contemplated?
Not necessarily, Justice. Part 6 does not require a third device to constitute an interception. What it requires, and what the Crown Intel's Communications was concerned with, was the state acquisition of the private conversation through technological means. And in case of text messaging, the permanent record allows for exactly that acquisition of information.
But isn't that the third party is the state, right? Like there's conversations between person A and person B. And so the state intercepts those conversations. So the state is the third person. Whereas here, the state is the second person, right? Like there is a break, is there not, between those?
There is a difference, Justice, yes, but we would say that in moving our jurisprudence with the Charter, we have to adapt to new police techniques. Again, the point is that we don't need an exhaustive interpretation of Part 6 requiring certain technical requirements. If there is an interception of a conversation through technological means, like in this case.
Sorry, Counsel, is the wording of the interception provision as it stands now broad enough to allow your interpretation? Or are you asking this court to go outside the bounds of that law?
No, Justice, we would not, because the current definition does not require a separate device or apparatus. We're not in Parliament, we're not going to create new legislation. We would say that that definition is sufficient for our position.
So one of the things the definition does include, Counsel, is that law enforcement is employing intrusive surveillance technology. Where do we find that particular application of the definition here?
Well, Justice, again, we have a broad interpretation of what technology means. And in that definition, they say it could be a physical hearing device between a wall or some sort of sophisticated
What makes
type
it
of electronic.
intrusive surveillance?
It's the fact of the police investigative technique in this case, Justice. The fact that they intrude on the conversation through technological means can qualify this as an interception. As noted in Duarte, what was illegal in that case was the surreptitious recording of the conversation. We say that the medium of text messaging allows for exactly that.
It was a wiretap, right? So the conversation is tapped. So that is fundamentally different. Right?
Just be mindful of, in your response, you have to answer my colleague's
Could I
question.
ask for a moment's indulgence, Tim?
That is your 15 minutes, so.
Oh, sorry.
So you can answer, Ms. Wu, you can answer my colleague's question, and that will wrap up your submission.
We would submit that that was a concern at the time, but again, our broad interpretation of Part 6 must allow for us to adapt to other police techniques to ensure the protection of charter rights. Barring any further questions, this concludes the first submissions on behalf of the appellant.
May I proceed?
Go ahead.
Good afternoon, Justice, Chief Justice. My name is Michaela Mifsud, and I'll be conducting the final submissions on behalf of the appellant in the case at bar. I have two submissions to conclude with today. First, we submit that the conduct by the police was not authorized under Section 11(7) of the Controlled Drugs and Substances Act. For our fourth and final submission, it is our position that the evidence ought to be excluded in this case. In the courts below, our friends have argued that the warrantless search at issue today was reasonable and in fact authorized by Section 11.7 due to exigent circumstances. It is the appellant's position that the facts of this case do not amount to a finding of exigent circumstances. In Hunter, this court established the framework for how warrantless searches should be examined. Justice Dixon held that though it is not reasonable to insist on authorizations in every instance, where it is feasible to obtain prior authorization, it is necessary for a valid search and seizure.
Here, Parliament has stepped in and said to the police and the state, look, if you have exigent circumstances and getting a warrant, it's not practicable to get a warrant, you don't need it. Go on in. And so when I look at the facts of this case, right, you have, first of all, heroin laced with fentanyl. You have a drug transaction that's going to happen. It's just a matter of when, not if.
That is correct.
And so I'm having a hard time understanding what was not immediate about the transaction and what was not urgent about the police conduct here.
Well, the appellant would submit that there was no temporal constraint here that the police were faced with. In cases of exigency, of course, there has to be a strict temporal constraint which prompt the immediate action. So, for example, if we turn to the case of the Crown and McDonald, it was found that the police conduct in responding to a noise complaint was justified because the officers had spotted what appeared to be a gun, which indeed it was.
Counsel, here, police have one party under arrest with drugs, text messages that are plain view that seem to indicate there's an impatient drug dealer on their hands looking to offload product. And the window of opportunity to act isn't that the temporal issue? If the police didn't act at that exact point in time, the line to Mr. Campbell, if I can put it that way, would have been extinguished.
Justice, I'll answer your question in two parts, if I may. Firstly, when we compare this situation in the case at bar to the cases of McDonald, for example, where the police had to act on the sudden in response to a gun, the immediate danger was right there. They had to act on the sudden. It was now or never. In the case at bar, several other transactions would have had to manifest for the public safety concerns to actually come to fruition. It depended on certain events unfolding in the future where the appellant would have to find someone else to sell the drugs to, and then that seller would have to buy them, they'd have to meet up, and then they would distribute the drugs.
Sorry, counsel, does there have to be public consumption of those drugs for there to be public safety, or is there not public safety concerns staring the police in the face, knowing that those drugs are on the move if they don't act?
Well, Justice, I'm hearing some concerns that were raised in Grant of 1993, where it was determined that even though in some cases exigent circumstances can be created when drugs are on the move in a car or conveyance, it's not a blanket statement. Just because narcotics may be on the move doesn't necessarily amount to a finding of exigent circumstances.
So it relates to the issue of exigency and urgency. Does the urgency not necessarily relate to the risk, but also for the need for immediate police action? The issue here isn't necessarily that there was some belief that the drugs would end up in vulnerable users within minutes. The risk was if officers didn't act right now, that those ultimate steps would occur. So the urgency doesn't have to exclusively relate to the risk, but the fact that they would essentially be letting this person go with no means to then further surveil or discern this person's identity as a potential drug dealer.
And just to build on that, wouldn't the fact that in the text message he said that he didn't want to drive around with it all day, wouldn't that further bolster the idea that if not now, he might distribute to someone else, it might disappear, he might dispose of them?
Well, Justice, in the text message that you're referring to, if you look to the one that was sent directly after that, he asks Mr. Gammy what time he's going to need it, the drugs by. The police could have opted to attempt to obtain a warrant at some point in the case at bar, but they didn't. And this indicates, this text message, that it could have been a possibility. They could have said to Mr. Gammy, yes, I can meet you in 2.5 hours or 3 hours, however long it would have taken them to obtain a telewarrant.
That's assuming the answer though, right? There's no guarantee he shows up in 2 hours, right? What if after half an hour he's antsy enough and wants to dispose of them, right? So just the fact that the police might respond to set a temporal element doesn't even mean that temporal element will be followed.
And sorry, just to add, I thought at the lower court below us, Mr. Campbell conceded that there was not enough time to get a warrant.
Justice, in the court below, Mr. Campbell conceded that it was impracticable to obtain a warrant. However, we would submit that impracticability cannot cause exigency. The exigency must have caused the impracticability as per Patterson. Additionally, there's no
exigency, though, not just related to public safety. In Section 11, Sub 5 of the Act, you also have exigency for the purpose of seizing a controlled substance.
That is correct, Justice, but the appellant has put forth the argument, and the police put forth the argument, that it was done for public safety. That was the reason behind their finding of exigent circumstances in the moment. Additionally, there is no evidence...
In these circumstances, would it be warranted to seize the drugs and therefore not require a warrant?
The appellant would submit that it would not be appropriate, as it is still our position that there was no temporal time constraint that would have prompted the officers to act immediately. And
Position that the Crown had to lead evidence that if the drugs weren't going to Mr. Gamby, they were going to go to someone else. The Crown has to lead actual evidence of that?
No, in fact, there is no evidence on the record that suggests that Dew had another buyer readily at his disposal or waiting in the wings, to use the terms of the court below.
If that's not required, and we can draw a common sense inference that drug dealers sell to multiple people, and one of the things that they want to do is get their product out the door as soon as possible, can we not draw the inference that if not Gamby, someone else?
Justice, in making this determination, we are to justify overriding charter rights. And the police in this situation, we would submit, were not faced with such a situation where the temporal constraints were so intense and so imminent that they had to override charter rights. And the last text message, which indicated the time that they were going to meet up, indicated to the police that it could not have been that urgent. Perhaps they could have, as I stated before, they could have set to meet up at a different time and gotten a warrant in that case.
So if the police did that, as you say, so the police text Gamby back and say, give me a couple, or sorry, Dew, back that phone and say, give me a couple hours, come on by, and then they go, they draft their ITO, they send it in for the telewarrant, and then during that period, Dew says, I gotta offload this ASAP. If you want it, I'm gonna come give it to you, or something to that effect. Does that change your analysis at the end of the day as to the urgency?
Absolutely, Justice. If Dew had indicated that he immediately wanted to get rid of the drugs, immediately wanted to dispose of them, that would change, and that would add a temporal constraint, which isn't present in the case at bar.
And so the Crown would have to lead that evidence. That's not is that an inference that the court can draw, or is that evidence that must be led?
Well, when we're deciding on whether the police's subjective view of exigent circumstances is reasonable, we have to see that it is objectively grounded in the facts of the case. And in the facts of this case, there was no buyer that was readily available to Dew. And if we are to stretch the definition of exigent circumstances beyond this narrow approach, which is stated in cases like Feeney, who instructs us that a safety risk must be specific, exceptional, and concrete, as exigent circumstances are narrowly defined. A serious crime by itself cannot define exigent circumstances. There must be concrete evidence for the police to move forward. If the police did not have evidence to suggest that another buyer was waiting in the wings for Dew, then we would submit that it's contrary to Feeney. And this creates the potential to allow for warrantless searches anytime the police have the opportunity to seize drugs, regardless of the absence of imminent harm.
Now, Ms. Mifsud, isn't it the case that typically drug dealers don't use the most clear and concrete terms and may be limited in the information they pass on to one another. So in future cases, you may not get that further information. So this is the typical case and the typical amount of information a police officer would receive.
Could you rephrase your question, Justice?
Well, I'm just wondering, you say the police needed more information. And my concern is typically drug transactions. They don't like to exchange a lot of information. They often use coded language. So in other instances, we may not get that further information. We often won't get that further information. I would suggest to you that this is a very typical, classic interaction.
Well, Justice, Feeney instructs us to have concrete evidence for exigent circumstances. And the appellant would submit that it's a combination of factors which amounted to a non-concrete case in the case at bar. We would submit that because of the text messages that were received, he was simply asking, what time do you want this?
Is he though, or are we sort of cherry picking one text message? Wasn't there not another text message where he's quite clear that he's not going to drive around with this product?
Absolutely, Justice, but there's no evidence on the record that suggests that Jew was actually on the move when he sent that text message. For all we know, he could have been at his house, and for all the police knew, he could have been at his house and could have been about to drive the car. We need to have concrete evidence in this case.
Do not draw an inference based on the timing of the messages. 4:31:23 p.m. Family, I need $12.50 for this half though. And then 4:50:26. So about 20 minutes goes by. He hasn't heard from Gamby. And then he texts him, yo, literally 22 seconds later, what you gonna need? And then another 11 seconds later. So can we not draw an inference that there's a sense of urgency on Dew or Campbell's part?
Well, Justice, the timing of the text messages and how rapidly they were sent doesn't necessarily indicate concretely that this was urgent or that he's impatient to get rid of the drugs in this instance.
What I don't understand is I'm worried that if we set a precedent that rapid text messages sent in succession from someone who is a known drug dealer in the community saying that he doesn't want to hold on to this product for long, if that's the standard that we're saying that does not allow the police to go in and interject themselves into this conversation, what are police to do? How much more can we possibly expect drug dealers to say about a conversation they're trying to keep very private in order for the police to be able to go in there?
We would ask police to use other avenues to obtain the information necessary to continue their investigation. So perhaps if they had gotten a warrant for the cell phone number, or perhaps...
Play it out. So they get a warrant for the cell phone number, right? Or they get a production order. And the production order says to the cell company, tell us where this phone is pinging. And it comes back on an intersection. Is that, like, what are the police to do? Go to that intersection and just ask every single person around, hey, is this your phone number? Are you due? Like, how does knowing the general area, because that's all you're going to get from a production order, effectively, and maybe an address, how is it going to help identify Dew and get the drugs off the street?
That is not the only way that police could have pursued this investigation, but merely a suggestion of one potential. But in the case at bar, of course, that wasn't sought. And the appellant would like to quickly turn to the grant factors and the Section 24.2 analysis. Due to the lack of exigent circumstances as we've found it, and the experience of the officers and the impersonation of GAMI, we would suggest that this branch strongly favors the exclusion of the evidence. I see my time has nearly elapsed. May I ask for a brief moment's indulgence?
Extra 30 seconds, yes.
And because of the nature of the conversation and the intrusiveness of the technique and the fact that this was only discoverable through a charter breach, we would submit that this branch pulls strongly towards the exclusion of the evidence. And finally, we would concede that the last branch pulls towards the inclusion of the evidence. And on a balance, the appellant would find that we ought to exclude the evidence. And so for these reasons, Justices, We respectfully ask that the Supreme Court of Osgoode Hall allow the appeal, set aside the appellant's convictions, and enter acquittals. Barring any further questions, this concludes submissions on behalf of the appellant.
Counsel for the respondent.
If I may proceed. Good afternoon, Chief Justice and honorable justices of this court. My name is Dylan Thompson, and I'm appearing alongside my co-counsel, Nolan Calderwood, on behalf of the respondent, His Majesty the King. Today, the respondent will present 4 submissions. I will address the first 2, and my co-counsel will address the latter 2. First, the appellant did not have a reasonable expectation of privacy, and the actions of the police did not constitute a search. Second, that the actions of the police did not fall under Part 6 and did not constitute an interception. My co-counsel will then address exigent circumstances and Section 24(2) and the exclusion of evidence. In light of these submissions, the respondent requests that this court dismiss the appeal and uphold the convictions. Turning to the appellant's first submission, the appellant did not have a reasonable expectation of privacy. In regards to reasonable expectation of privacy, only the 4th branch of the test laid out in TestLing is contested. This is the objective expectation of privacy. Mills paragraph 20 states that an objective expectation of privacy is to be analyzed on a normative standard. In essence, this refers to what Canadians in a free and just society would expect to attract a reasonable expectation of privacy. Our friends attempt to differentiate the case at bar from Mills by simply stating that in Mills, there was no pre-existing relationship, and in the case at bar, that there was. However, our friends did not turn to Mills page 26, paragraph 26, which states that expectations of privacy are to reflect a normative standard. This normative standard depends on the nature of the relationship in question and the circumstances surrounding it at the time of the alleged search.
Counsel, aren't the facts in Mills quite distinguishable from the facts here in terms of who the parties were communicating and whether a reasonable expectation of privacy would attach?
Yes, Justice, the facts were different. However, the core finding of Mills is that it determined that an objective expectation of privacy is dependent on the nature of the relationship and the circumstances that surround it.
The nature of the relationship here was effectively unknown. In Mills, the police knew that this was, a fictitious, fabricated child on the internet. In this case, the police have no knowledge about the nature of the relationship and what it could possibly mean. For as much as they knew, this could have been Mr. Gamby's brother.
Justice, the respondent submits that the relationship was known at the time of the search. 2 confidential informants have informed the police that Mr. Gamby was attempting to sell fentanyl and heroin. And furthermore, the 4 text messages that were required search incident to arrest demonstrated that the ongoing relationship was criminal in nature.
Just because it's criminal doesn't necessarily mean it may not also be close. The mere fact that this is a drug transaction doesn't exclude the possibility that it is also a potentially close relationship.
The idea of how close the relationship is not what is of the most importance. It is the circumstances that surround the relationship, and it is answered on a normative question. This means what should Canadians expect and what circumstances would have expectation of privacy. In the case at bar, the relationship was inherently criminal. 2 people trying to trade very illegal drugs that have wreaked havoc on many Canadian lives. Canadians on...
The normative question here appears to be that the circumstances of the relationship are one in which law enforcement has interjected itself and impersonated one of those people in the relationship. Isn't that what Canadians could and should be concerned about in regards to law enforcement?
Justice, in terms of the interjection of the police into the conversation, lots of jurisprudence, such as McQueen, has demonstrated that it is not the impersonation or deception that arises to privacy concerns. It is the secret recording of conversations that the appellant or the accused would not know of at the time. In the case at bar, the appellant was the one that created this record themselves. There was no secret recording done by the police. Duarte explicitly says that a person, in their risk analysis, that a person is not protected from the dangers of a, quote, tattletale. This is because a person cannot reasonably expect that when they're communicating with another person, that they will not disclose the information that is given to them.
Isn't the analysis content neutral? It's not, do Canadians have a concern about drug dealers talking to drug dealers, right? Isn't the question, do Canadians expect some level of privacy in their text communications with each other? So I text my mother, I expect a certain level of, a certain expectation of privacy. The extent of that remains to be seen. But isn't that the question, as opposed to drug dealers talking to drug dealers?
Justice, it does not breach the content neutrality aspect to Section 8 because the police were aware of this relationship from the onset. Similarly to Mills, as stated in paragraph 27, although Section 8 is not traditionally approached from the perspective of a particular relationship because it is content neutral, the police knew the relationship in advance of any potential privacy breach. The circumstances are the same. Before the potential privacy breach, the police were completely aware, due to the confidential informants and the text messages that required search incident to arrest, that there were no potential privacy breaches because Canadians would not expect two drug dealers who are attempting to traffic fentanyl and heroin would have that expectation of privacy.
When you say that there's a content-neutral approach and then discuss the expectations of Canadians in the context that this had a criminal content, where exactly does the content-neutral approach happen?
The content-neutral approach happens from the onset of the potential privacy breach. In the circumstances in the case at bar, the police were completely aware of these things legally. The text messages were required search incident to arrest. The confidential informants were spoken to the police before the arrest of Mr. Gamy. They were completely aware of the ongoing criminal nature. Anything learned after the fact would have breached the content neutrality. However,
incident to the arrest of Mr. Gamy, if that was a completely separate charge that he was being arrested for. So is it your position that the texts that they ended up investigating were incident to that arrest?
Justice, the text messages were also acquired due to the plain view doctrine. When the text messages appeared on the surface of the telephone, the cell phone, they had complete access with that, and according to the plain view doctrine, it was usable. Now, if this court...
But the issue isn't those four messages. That's not what the debate here is. I don't think anybody is arguing that those four messages as they popped up would fall into the plain view doctrine. The issue is the continued conversation with Mr. Gamy. With Mr. Dew, or the phone that was, I'll call it Dew for now, but turned out to be Campbell. That's the issue here.
Justice, that question turns to the third branch of the three factors outlined in Campbell paragraph 54 that refer to the objective expectation of privacy, and it explicitly refers to the police intrusiveness. Justice, if you're suggesting that the privacy breach comes from the potential information that could have been learned after the police initiated the conversation, it is a finding of fact that the only information that was extracted from the preceding 35 messages was purely only based off of the time of arrival and the potential location that the accused was at that moment. That does not go to the core biographical information of the accused. Now,
assuming that the police can control what information the other person's sending, right? So a question of where you at potentially has a lot of different answers that could reveal core biographical information. I'm at home, I'm at my girlfriend's, I'm at the bar, I'm at the airport. Do you see what I mean?
Jurisprudence, Justice, would disagree with that statement, as in Bierstow, the similar circumstances occurred where a police used a seized phone in order to impersonate an accused, and as a result, it led to the arrest of the appellant. And in this case as well, text messages were sent trying to gather where their location was, and it was the finding of that court that it did not constitute a breach and it did not constitute an interception either. Moving to the other two...
Sorry, counsel, there's also a case law to suggest that core biographical information has been expanded or at least clarified to include things like lifestyle and personal choices, right? Which is clearly in contention here as well. So that information being garnered by the police should in fact fall under core biographical information. I don't know if it's quite as narrow as you're telling us it is.
The court in Bierstow, however, disagreed with that suggestion, Justice, saying that the asking of location did not constitute core biographical information. Furthermore,
in the case of Bikevitz, where IP addresses were found out for reasonable expectation of privacy, the idea of what is core biographical information is ever expanding, and so perhaps things like location should in fact attract that expectation of privacy.
Bikevitz referred to the secret acquisition of an IP address. However, of significance in Bikevitz was the idea that this was a record that was acquired without the knowledge of the accused. In the case at bar, referring to Duarte, where a person is not protected by the, quote, tattletailer, the accused explicitly made the record themselves, which means there was no secret recording done by the police in order to acquire this information.
A little bit, I mean, Maraca kind of changes that idea. You can't be protected by the tattletailer. I understand you can't prevent somebody from going to the police. My colleague and I exchanging a drug deal, I can't stop him from going to the police. But the idea that the police can get into his text messages or my text messages or a phone that we're using that doesn't really belong to any of us, it's an organization phone, that's where I'm having some difficulty.
Like, are the police acting as the tattletale then? Are they tattletaling to themselves? That seems like logically doesn't make sense.
Apologies, Justice, if you could please repeat that question.
Yeah, let me just further to my brother Justice's question, right? Like, are you trying to say then that the police are the ones who count as the tattletale? Because logically, it doesn't seem to follow they're the ones telling them, like, to themselves. Like, I'm not following the logic.
Justice, McQueen also states that although a person may be deceived as to the identity of the person that they are talking to, it does not change the fact that the person on the other end of the device is indeed the intended recipient. And just because the intended recipient doesn't end up being the person they thought it was, does not mean that it amounts to an interception or that it breaches their privacy expectations. Now, speaking of McQueen, moving towards the respondent's second submission, that the actions of the police did not constitute an interception. The appellant argues that police deception about their identity can amount to an interception. But legislation in Part 6 only protects intrusions by third parties.
It wasn't Part 6 drafted at a time when the technology was you needed some other device in order to tap into a phone call, right? Like this, we're talking, it's organized crime, right? We're tapping into phone calls. The technology is advanced. Can the court not advance? Does that section not, is it not like a living tree?
The respondent submits that police techniques also need to adapt to ongoing technologies, and that Section 8 and Part 6 finds a balance between the abilities for the state to intrude on a person's privacy and the ability for police to enforce the safety of the public.
What's the new technology that law enforcement was adapting to here? Is it text messages? Is that what you're suggesting the new technology is?
Yes, Justice. The new digital era is completely surrounds the world by telecommunications. However,
we have many cases dealing with text messages.
The Crown and Bierstow, Justice. Sorry? The Crown and Bierstow.
But we have many cases, is what I'm saying, dealing with text messages. What makes it new in this case and in these circumstances that law enforcement needs to adapt to it?
These circumstances is the idea that if we were to take our friend's approach, that the police would be limited in their ability to formulate undercover operations simply because it occurs over the cellular device. It's the respondent's position that Part 6 laws are already flexible enough to...
I think their position was that it's not just that it occurred over a phone, it's also the intrusiveness of the police's conduct, the fact that they went and impersonated someone, effectively hijacking a pre-existing relationship.
However, lots of jurisprudence has clearly defined that deception does not amount to interception. So simply the act of deceiving one's identity in order to acquire information has been long-standing not a factor to reach that conclusion.
Does that change when we add an impersonation as well as the fact that this is occurring over a private text message conversation?
Yes, in Duarte, explicitly, Duarte and Wong both involved a conversation with an undercover officer. However, the reason why they were not, that aspect was not deemed to be an interception is because Duarte specifically says that the intrusion comes when the police and the state themselves make a record secretly. In this case, the appellant made the record themselves knowingly and took that risk. This concludes our argument that interception requires intrusive technology. It only protects it when there is a third party, and that deception does not amount to interception. I will now turn the floor to my co-counsel in order to address the remaining submissions. Thank you, Justices.
May I proceed? Good afternoon, Chief Justice, Honorable Justices of the Court. My name is Nolan Calderwood, and I will be concluding with 2 submissions on behalf of the respondent. Justice, to clarify from the onset, I adopt the positions of my colleague. However, if the Court does not accept that this was not a search under Section 8, it is nevertheless our position that the Section 8 rights were not breached, as the search was justified by exigent circumstances under Section 11(7) of the CDSA. Justice, my second submission will go to the further alternative that the admission of evidence would not bring the administration of justice into disrepute. Turning to my first submission, it appears we depart from the reasoning of our friends on the imminency of harm required to establish urgency under Section 11(7) of the CDSA. Justice, what defines urgency is not defined in either the statute nor is it defined in the common law in Patterson. The Court in McDonald provides a 3-part test to determine the boundaries of police power in a given situation. From the onset, I would like to address some concerns from our friends that McDonald may not be an appropriate authority for this inquiry. Justice, there was suggestion that McDonald related only to weaponry and when it was before the police. However, I'd note in paragraph 37, McDonald set out a general test for the police powers, and this has been applied to many circumstances, like sniffer dogs in Shea Hill or searches of residents in Stairs. Justices, turning to the first branch of the McDonald inquiry, it's the importance of the police duty in the circumstance.
In this case, the officers spoke with who they thought was due for 2 hours after the initial contact, right? Presumably to set up the transaction. So it's not like Due was around the corner or Campbell was around the corner. What do you say to your friend's argument? That all they had to do was just text, hey man, I'm not available right now. Come by in a couple hours, I'm out. Paused, they've secured the intention to purchase. Due is happy. Then they go get their warrant. And in the meantime, if the circumstances change, you address it. What do you say to that approach?
So, Justice, I would defer to paragraph 37 at Patterson that does not just ask if there are other alternatives available, but if these alternatives would pose serious risks to the imperative of protecting life and safety. Justice Sergeant Baer identified in his testimony that drug traffickers do not traffic to just one person, and that it was likely that drug traffickers would not drive around for heroin for days or even hours in that instance. In combination with Due's impatience displayed in his text messages, It's our position that the drugs would have imminently been moved outside of the reach of the police.
In the words of the text messages as I read them, is Dew being impatient? What words is he using to show he's being impatient?
Justice, it would be the text message inferring that stating that he did not want to drive around with it.
Okay, but that doesn't mean impatience. That just means he doesn't want to drive around with drugs, right? Not wanting to drive around with drugs doesn't mean impatience, because there's no evidence that he was physically out on the road, correct?
Justice, not directly, no.
Well, there was no indirect evidence either, right, that he was out on the road. So the police they speculated, let's say. But just look at the messages. The last message is, what time you going to need it? Not, I'm there, I'm around the corner, it's happening now. What time? And all they had to say was, it's 4:50 now, come by at 6:50.
Justice, I'd say even that message under our friend's position would not be allowed. They said if the harm is not imminent, that the police cannot conduct the search. Under their position, even that message would be a search.
But Amanda, you said the messages showed urgency. So I'm trying to understand what in the messages is urgent.
Yes, Justice, I would say that it is the fact that he did text that I do not want to drive around with it. I'd note that they do not need concrete proof that means he is going to offload them imminently, rather reasonable and probable grounds to believe he would offload the drugs outside of the police reach. I'd also like to note the timing of the text messages. At 4:31, Mr. Campbell Dew texts offering him the drugs, $1,250 for half an ounce. It is then 20 minutes later where he responds with 3 text messages encouraging when he is going to need them and that he does not want to drive around with them.
Sorry, so when you're being asked about urgency, you're relying on the third or fourth text messages, so just specifically that one, even though the subsequent message seems to give opportunity to delay the transaction. But then in the same breath, you're asking us to conjunctively read the timing of all the texts together, right? So it feels like the Crown is picking and choosing at what instance we can read them together or individually. Can you speak to that?
Yes, Justice Diaz. I would say that the third message does propose an alternative for the police to perhaps delay the sale till tomorrow. However, the standard outlined in paragraph 39 under the extent of the infringement branch of McDonald does not say, was there alternatives? It rather just mandates that police only conduct the search to the extent that is necessary to serve a protective function. Justices, the police only spoke of directions, time of arrival, and his location. They did what was necessary in the situation to ensure the drugs were secured.
Isn't the governing case law Patterson on exigency?
Yes, Justice. The governing case law is Patterson. However, I will note in paragraph 40, the trial judge did not entertain the public safety branch. As first, it was not the driving reason the police entered his home, and second, because it dealt with a shotgun, which is not governed under the CDSA.
No, but factually, Patterson is different, but Patterson sets out the legal framework for how we assess urgency, right?
Yes, Justice. Patterson primarily sets out that urgency must be the source of impracticability, but we would ask this court to turn to the common law to define what urgency is and the bounds of it.
So in the absence of an attempt to delay the transaction for a couple hours, right? Because I think you can concede that last sentence suggests an ability to defer, correct? So in the absence of any evidence that any attempts were made, how then on Patterson do we get to immediate police action is needed when they had the ability to delay but chose not to?
Yes, Justice, and I would point to 2 points from Sergeant Baer's testimony. Primarily that drug dealers do not just traffic to one person, and it's entirely possible that if the police have responded that they did not want the drugs till later, that they would have been trafficked elsewhere. And second, if they had deferred the transaction, say, to the next morning, it is also possible that Mr. Dew would hear that Mr. Gamey would be arrested and thus turn off the phone entirely.
Are you not speculating here? How's he going to find out Gamby was arrested? Is Gamby going to go tell him?
Justice, I accept there is some speculation to that, but there were multiple concerns identified by the police officers that the drugs would be moved elsewhere if they did not respond imminently.
So then wouldn't that lead to the result that effectively all investigations into potential drug deals would result in these circumstances?
Chief Justice Rappos, not necessarily. I would say if any of the circumstances relating to the McDonald factors changed, it may not apply in this case. Say if it was a less serious drug, or even if the threat of fentanyl in a different area was less compelling. Second, if the necessity was reduced, say if they knew who Do was and had other options to locate him. And third, if the extent of the search was not conducted narrowly. If the police sought to elicit evidence beyond serving what a protective function is, it may have been a charter breach in that instance.
If we were dealing with crack cocaine, would you say that would be urgent? Would crack cocaine?
Justice, I would say no, that would not fulfill the urgency requirement.
How about heroin on its own?
Justice, also I would say no, that would not, based on the evidence in front of us relating to fentanyl.
Is it fair then it's the fact of the fentanyl
Justice,
that creates the urgency?
Justice, to some degree, yes. The police duty in the case, if it was related to a less dangerous drug, would better be characterized as the prevention of crime rather than the protection of life and safety.
What about a firearm?
Justice, I would characterize that potentially as the preservation of life. However, with firearms, there is no indication that they will be used imminently. However,
this was ongoing surveillance. It's a very common police technique to surveil drug houses, drug cars, suspected drug dealers, follow them around, potentially even view possible hand-to-hand transactions. That's an extremely common police technique as opposed to what we have here, which is more unique. Would your submission essentially allow for warrantless searches anytime police believe they may be witnessing a hand-to-hand transaction?
Justice, I would say not necessarily. To take the examples of a vehicle or a house, the police could remain present and ensure that the dangerous drugs are not moved to users by, say, as you've put it, following the source of the drugs. In this case, they became aware that the drugs were remote and had no other option to locate Do besides responding to his messages. Justices, I would just like to briefly address that it is our position urgency was established, and as Patterson contends, urgency must be shown to be the source of impracticability. I would note the trial judge made a finding of fact that it was unlikely that a telewarrant would arrive in time to complete the strict transaction in the area.
What evidence did the trial judge rely on, though, in making that finding of fact?
Justice, he relied on the testimony of Sergeant Bear, and I will note that potentially empirical evidence would be useful. However, that was a finding of fact, reviewable on the standard of a palpable and overriding error, and we are absent submissions from our friends on that point.
Didn't Sergeant Bear also indicate that he believed the police could proceed without a warrant because they were not trying to gather evidence against Gammy?
Yes, Justice.
So that seems to speak directly against the imminency. It was more a convenience factor.
Justice, I'd say that statement must be informed with context. I'd note this situation occurred in 2017 when the governing authority was America for messages in a co-accused cell phone. And the holding there was that there was no reasonable expectation of privacy in the text messages, and I would inform his statements based on those circumstances.
Isn't it true that if the police were unsure at all about the state of the law and what they could do in these circumstances, that it would be better for them to err on the side of caution and try to obtain a warrant?
Justice, I would answer that question in two parts. First, that may be preferable, but I would say in the context of America, in combination with Baldry, which held that the police can answer an accused cell phone, they had I'd say it was reasonable for them in the situation to conduct the search. And finally, I would just like to address briefly the exclusion of evidence under Section 24.2. We will be proceeding based on the three branches provided by Grant. The first being the seriousness of the charter infringing state conduct. We would find that in this case, it was properly characterized as a technical or inadvertent charter breach based on the holding of America. I would also note that the police actively turned their minds to the idea of a warrant, and thus it would not be appropriate to place their conduct on the high end of the scale of culpability, which is reserved for willful or reckless disregards of charter rights. Justices, turning to the second branch of Grant, the impact on the charter-protected interests of the accused, and we would say any impacts were minimal in this case. First, that any knowledge of his criminal activity was already known to the police lawfully through the powers of search incident to arrest in the plain view doctrine. And second, the only information they elicited was regarding his location, time of arrival. And I note, pursuant to the second factor of McDonald, that anything to do with eliciting this information was a protective function for the police. Justice, finally, the third branch of Grant asks for society's interest in an adjudication of the case on its merits. The first factor of that is the reliability of the evidence. It's our position it's high in this case.
If we find, counsel, that the breach was not insignificant, as you say, but that the breach was a significant breach, how does that change the third prong of the 24-2 analysis? Because I suspect you're going to say the administration of justice would not be brought into disrepute by a minor technical breach where the police acted in good faith and whatnot. But if we flip that and say that there was a significant breach, it wasn't technical, what do you say on the admission point?
Justice, even if this court had decided the first branch strongly favored exclusion, it's our position that the second only slightly favoring exclusion, in the third branch strongly favoring inclusion due to reliability, significance, and society's interest in prosecuting fentanyl-related offenses would outweigh this, and the admission of evidence would not bring the administration of justice into disrepute. Barring any further questions, concludes our submissions. Thank you.
Okay, the court will deliberate in chambers for a few moments, and then we'll return with our decision. Thank you. Again, thank you all for your participation in this wonderful event. I don't want to repeat what I've said, but again, everyone should be proud of the level of preparation and advocacy that they've presented over this weekend. It's a really strong testimony to the quality of students you are now, and hopefully lead to law school and careers as lawyers. So the panel of 9 of us deliberated. It was a very difficult decision. Again, the level of the advocacy that these 4 individuals displayed, as you witnessed, was fantastic. They dealt with difficult questions. They spoke and reacted on their feet exceptionally well. And unfortunately, as with every case, there's only usually one successful party. And here, I'm very happy to announce that the successful winners of the Osgoode Cup 21st anniversary are Helen Wu,
So our final two teams, I forgot to announce, our appellant team and champions of the 21st annual Osgoode Cup are from McMaster University. Our runners-up are from Western.